Wednesday morning, May 7th, and we're going to start by looking not so much at the language at S12, but to understand about documents and retention policies and all those good things. And I will welcome the state archivist, if you could please join us. And it's in the context of S12, the sealing bill. So if you identify yourself for the record and
Well, good morning. So I'm Tanya Marshall. I'm the Chief Records Officer and the State Archivist and the Director of the Vermont State Archives and Records Administration. We're a division of the Secretary of State's office, and I appreciate the opportunity to be here. I know I was here last year, but some of you may not know me per se. I did provide two documents that are available to you. One is a general overview of the Vermont State Archives and Records Administration. So it just provides context for who we are, what we do, the different services and programs that we offer, and also the context of the law that we work in related to public records management and information management, and then the state archives functions as well as other functions that we do, including legislative clerking and ministerial rules and the ministerial processes of the Secretary of State. And then the other document specific around S112, and then what we see or how we interact with all the different entities that are involved in the sealing expungement process, and also where we may also have records that are affected by the sealing and expungement. So feel free to, ask any questions at any time. And I do have, there's two different documents, so some are just supplemental for reference. By way of background, just so everyone knows, my particular background is that I'm an information scientist by background. I've been with the state since 2003. Our archives law was passed. It was Act 1 of 2003 to essentially allow the Secretary of State's office to identify throughout all three branches of government records that should be preserved permanently and be on a pathway to permanent preservation and access. And so there's criteria around that. When we say permanent, it's not permanent within the lifetime of a person and not permanent within the lifetime of, an organization or a building or what have you. It is permanent. We expect that it would be here 200, 300, 400 years from now. And that was the original. It was part-time, temporary. It just happened to be in Vermont, had located here and got a call. And at the same time, the Judiciary had an appropriation related to managing records that was really based on old sets of records, and they were going to lose that appropriation. So I actually worked part-time for the Court Administrator's Office for 2 years as well. And quickly going into the courthouses, realized that if not the older records that we should be really focused on right now, we should be focused on the current contemporary staff and the records management issues there. And so in 2005, 20 years ago, the legislature asked for two preliminary strategic plans to be established, one for the executive branch and one for the judicial branch. So I was part of those processes as a temporary employee, and the Secretary of State's office opened a permanent position. And I've been there since September 2005. But continue to work with the judiciary. So that's just my background. Information science is about how do you manage information? How do you store it? How do you retrieve it? How do you make it accessible to people who want it when they need it? And how do you make it easier for everyone to do their actual work as part of that process? So for S112, what I've outlined in here is just really 4 bullet points to talk to the committee about and to just get your thought processes around what we see when it comes to sealing and expungement, and then also what we do and see with your laws, which is our laws, I could say, because we dissect each one of them, and there's a second page in there that talks about that. But our core focus is really the statewide records and information management program. It covers everything that's written or recorded in the course of agency business. That is the definition of public record. Public record doesn't mean confidential or not confidential, it just means government. And even though the judiciary is kind of outside of that Public Records Act based on current court rulings, we still work collaboratively with them. Our idea is not on a branch. We're apolitical. We want people to have information to them and available to them. So we oversee that statewide records and information management program. And it's really about having these strong programs for every single entity involved. And then within the state, how do we have a statewide program that was really supported and seeing where all these things intersect to make everyone's role easier, and also to have compliance with the laws that at the state level and at the federal level were applicable. So it's really this management layer that we oversee and try to administer in a implement that really helps with these people, processes, and technology decisions that happen throughout the state. So the first thing that we do, and where we're intersecting right now, is ceilings and expungement, and it's actually just 2 weeks ago that it came up with a particular agency, is we do a lot of management guidance. So this would be related to records and information that are actually on site or being managed within the systems of those particular entities. And we do that within the context is that even though we have overarching laws, such as S112, each has their own individual laws. So our key part is always understanding what are all the different laws and requirements around records and information for that particular entity. And then we look at what their internal controls and procedures are. 2 weeks ago, there was a call from, we have a lot of district offices for some of the entities or different locations. And, while everyone has the goal of uniformity within their own agency or department or court or what have you, the fact that there's different locations and they come from different timeframes and different processes, it's not always known. I mean, it's kind of known, but not really known what it looks like inside. And so the ceiling expungement question that came up 2 weeks ago came up because, a procedure went out that sounded very simplistic and easy to do, but when in reality, it wasn't easy or simplistic to do, and it's a lot of extra work for staff. It doesn't mean that the ceiling or expungement isn't paid to do. It's just that that procedure didn't really match the records and didn't processes. So maybe that's going to be a summer project that we're going to get involved in, but we can't, services that we provide, people have to ask them. I mean, we don't kind of like force ourselves into any situation, but we love it when people do reach out because we love to problem solve around that. So even on the ceiling expungement, we're trying to run this assuming that there's really good internal controls and procedures already for managing information. There's links and there's weaknesses in each area, and we're not as strong. We're definitely stronger than we were 20 years ago, but we're not as strong as managing information as a state. So just keep that in mind because there's many layers. The other things that come up with internal management guidance that will get questions is there's legacy records and legacy system. The state of Vermont was really a storage. That's what it was. Records and information management until 2008 was done by Buildings and General. Well, at that point it was done by Buildings and General Services. So it's really just paper records and moving them out to Middlesex, which is where we're located. And the idea then was we're overwhelmed with paper records. So let's make them tiny and small and put them on microfilm. Some formats just aren't going to be conducive for sealing and expungement, and keeping that in mind. And it's not something that the current, records custodian is responsible for making decisions on. It's just the reality of that was decisions made. We all kind of live in that past and try to overcome that. And then, what we really are trying to get in front of is day forward. Legislation passes, we know exactly what the legal requirements are, we know the expectations, we're able to look at the management plans. We're working now on this post-COVID all in digital format for the most part, and looking at that data management. So we have abilities to use data in different ways to really help facilitate the sealing and expungement components, and maybe look at them in a different way than what we have done with paper physical records in the past. But also system design and requirements. What we see is a lot of technology, and I think for perspective, and I have it a little bit lower, so you'll see some of these overlap, is that, in the executive branch alone, we have 400 FTEs on technology from a business analyst perspective, a project management perspective, an information technology perspective, enterprise system-wise for most things that are like Microsoft related products. We have 2 FTEs outside of the Vermont State Archives and Records Administration allocated, and that has been because of the SARA advocating for it. And they're wonderful. Just one FTE, for example, in human services is supporting different agencies and departments, and there is like a structure within the law about people having it as duties as otherwise assigned. But when we finally find out about a system or it's after the fact, what we don't see are understanding of the laws that are passed by the legislature or the federal law down to the actual components of how to do this. And I think some of the testimony and what I've been watching, and I think you've been asking really good questions is, well, all of you have, but I think one of the more recent ones was like, what do you mean your system can't seal, right? Or I see some of the questions and and individuals not quite understanding what you're asking, because SEAL is in addition to, there's one part about public accessibility, right? And saying no record exists, no record found. But sealing is also to limit within your own purview of your system of who actually knows that record even exists. And we don't see systems, even though sealings and expungement predates any technology from a process. And so sometimes we see automation of paper processes versus innovative, so we're kind of in the mix with the agency. So this is just related to our management guidance when it's something outside of our controls per se, but where we're really trying to guide. So I'll pause at that particular bullet to take any questions.
Thank you. This is super helpful. I know you've given us some of the background before, but it's always good to get it in context of a new bill. So one thing I'm curious about is who gets to decide what technology will be utilized? Is it? Yeah, I don't.
It's hard for me to answer that question. When I started, and I'd hate to sometimes flash back, but I can at least give you some context of where it looks right now, is that, when I started with the state and we're doing these strategic planning for the judiciary and for the executive branch, and I am in the executive branch, but it's kind of not branch specific, I would say, for the work. And we do local government services, so it's not just state. The Department for Information and Innovation was stood up around the same time. And so we were actually operating in parallel, and each agency and department still had their own technology group, but they were within the purview of those secretaries and commissioners when it came to making business decisions that really aligned with, parts of it. I would say, and it's not about the current agency administration per se, but when that switch happened between the Department of Information and Innovation and the creation of ADS, we were kind of dropped. And what we're now trying to do is rebuild those relationships with a larger agency, and often through the agency themselves, because those are really the practitioners and the business leads, and they're not the IT.
So it's interesting because over the years, and even this year, we hear from departments that are going to buy or contract or sign a contract to buy expensive services or software that is going to collect data. And it seems like one of the boxes that people should check is, have you checked with the state like it seems like that would be important to get your input before somebody buys something and you're like, oh my gosh, this isn't gonna.
We had parts of that. I mean, one thing to keep with our scope is that, and sometimes it gets tailored saying, have you gotten like a policy from the state archives? But it's really about knowing a lot more. And so there is a page 3 that I'll get to, like on my next bullet, that talks about these consistency and uniformities and how it can be addressed earlier in the process and how it can be addressed on the onset of knowing that you want to improve your processes with technology. But that isn't necessarily, and I can't answer for every system, but I would say usually more often than not, the management questions we get are also learning that people have transitioned to a new system and it has gaps, right?
Right.
That could have been closed earlier.
Right. And could have talked to.
It could have been innovated.
Yeah.
I think that's the key
Yeah.
part. And one of the, challenges on information, not challenges, but one of the key parts for having more information professionals. And, I have a master's degree, but it's also in a doctoral program, which most people don't do, but it was focused on government records. And to date myself too, it was, late 90s, early 2000s when it was more tied with the federal government, but this tipping point between paper record keeping systems and digital government, and really being on the forefront of planning for digital government transformations, because you're not to innovate paper processes, you're to innovate or not automate paper processes, you're to innovate the use of technology to meet those compliance requirements. So I can't answer. I would say that for the systems that intersect with these, and so where we've had management questions, they're not optimized for those teams to do what they could be doing, if that helps.
And I assume there are some departments that participate more or work with you more than others. Like, are there any that just are like, we do our own thing? And
I mean, there's a requirement in the statute that goes back to 1937 that no one can destroy a public record, which is, again, written or recorded information. Public doesn't mean confidential, not without either it has to be by law. There needs to be something in the legislature. And we did have the question when that came up, when it was moved into the Vermont Public Records Act. It used to be in Title 22 about sealing and expungement orders. Like, is that considered to be in yes? And Michael Grady asked that question, and through to the judiciary, to us, and to the legislators, and we all agree that that's an example of authorized by law, right? Or a record schedule as issued by the state archivist, and that's really hedge against destroying tribal records that would prevent the state from, or an individual from, seeking, right? So sometimes we have them in that fast. There's this perception like a record schedule just goes poof and it's out there, but it's really designed to be a collaborative process with that agency and department. So we can find these gaps early. We can also report back to the legislature, or they can be able to show where there's conflicts in the law or things that are not working for them. And when I have the second part, I can talk about how we do that, because everything that we do is based on legislation. It's we are when I get to that part, you'll just see it is, we probably know more. It's not so much from a legal, well, we won't look at the policy. It is about what is being asked to be created or received in the course of agency businesses, written or recorded. And where are all these intersections happening? And what is whose function and where can we do better? So I would say there are definitely, I could answer from a sizing perspective that gives some idea, meaning we could have different entities that just create and have to have a lot of records, but are actually trying to manage them. And we have others that maybe aren't trying to manage them, and they just keep accumulating to a point that is very difficult then when these kinds of things happen. And then we do operate 3 repositories statewide, so we can have some things about that. Thank you. Yeah, and we do publish who has record schedules, but they're not, oftentimes it'd be like, well, I just need a record schedule, and like check off the box. And a record schedule is really designed to be a collaborative transdisciplinary exercise within that agency to help them really move into a better position. Yeah.
Can you expand, while we're on the subject of the record schedules, can you expand a little bit on that, and what record schedules might be relevant to criminal records?
Yeah, so
the Department of State's attorneys, the Attorney General's office, others.
Yeah, so that's our core kind of deliverable for the state, and statute is a record schedule. So the definition of that, it is a policy that is a life cycle management policy related to when record is actively needed, when it goes into inactivity. So say like case is closed, right? That's kind of moving into semi-active, active, inactive state. And then retention and disposition. And we also set security codes, and security codes are based on whether or not that record is exempt underneath the Public Records Act from public inspection and copying, or there's a federal requirement. And that's inclusive of any parts of the statute or rule that we might say, like a court rule, that will stay confidential. I do sit on the court rules for public access to court records as well. And so there's different language that's sometimes used there. So it does have a coding on that, and we designed those schedules to be for electronic records, and then retrospectively applied them to paper records, because papers are kind of bundled. So state's attorney, attorney general's office, law enforcement, meaning state police and municipal law enforcement, they have all gone through a form of the scheduling process with us to have record schedules issued to them. When we do scheduling, and there's a diagram on page 2 of this for the Vermont Functional Classification System. There's ways done in different states. When I first came here with this charge of, try to figure out everything that could be permanent archival and make it all work, there's a macro component to it, right? We have to see a very holistic of everything that's currently required and needed, and then really drill that down into some management parts for it. So it is actually driven by the laws. So when we do a record schedule process, and there's page 2 and there's page 4 of what I submitted. Page 2 is the first start of it, is that we actually go into the statute. So if we're writing state's attorney, for example, we will go into the statutes, find every instance of state's attorneys to find out what is their core function as defined by the legislature. And there's two parts to that functional area. One is considered to be what is the area of accountability, because that's going to cross in different areas, right? The court might be adjudicating a case on a matter like a misdemeanor, but it's going to be the state's attorney that's prosecuting on it. So there's intersections on that. And then the term that we would use, misdemeanors, for example, we look to see has a legislature defined what that terminology is, and we use that. And it's one way that we've been able to do uniformity and consistency, so that even if they call it something different in this office and they call it something different in that office, the truth is going to be objectively what the legislature has said the term is and what the definition is. Does that at least help with that concept? And then every day transactions happen, right, to fulfill this role. And transactions are just records. I mean, unless I'm talking, like I'm talking to you right now, but you're recording, so it's a record. If we were just talking into the room and no one was writing anything down, then it's not really a written recorded documentation of it. But transactions happen all day long. And we start with your statutes. I say yours, but I really mean ours. We start with our statutes, and if there's federal applicability, to identify every single instance where there is a language that will say, for example, it may say, shall provide written notice of XYZ. So we have a category of record for notices, and then we'll compile all legal requirements around that particular notice for that particular entity. It may say shall notify. So it's not really saying a record to be created, but it's implying pretty heavily. So we have a category, just accountability, like you'd expect to see those in there. And then we really attach, so it's inside a system that we call the Vermont Functional Classification System, and we attach that all. So on the last page, I did summaries because the laws change and we are fluid with the laws. So after each, end of the session, we're going through every place that we've scheduled records on to figure out if there's a statutory change that we have to make. And just keep that in mind too, as we do legacy records and we look forward. It may not just be this committee that's making changes on a statute, and we can offer services. Like one of the things that we always offer to legislators, if you would like us to do a functional analysis of everything within that bill to help inform on the information management parts of it, we can do that. We don't need a report. We don't need legislation to ask us to do that. We're happy to, if you have a report that you'd like us to formulate, but we do this, and sometimes we're doing this during the summer with different legislators on different matters that they feel, because it helps inform. So the areas that just looking at, the start of something is really these offenses being investigated, and that's going to start at local law enforcement and state police. And so we have a whole rubric around that in terms of management. And of course, some things are investigated and still open, right? So there's a whole way of framing around how to manage around unsolved, components, or things that are maybe, civil violation complaints, and we have a different mechanism for how that's done. And we take the best definition. So sometimes the definition's not in the same section. And so we've had attorneys, say, hey, that's not really the same, but it's still holistically, if the legislature was looking at it holistically, it's usually the best definition, because management, if we can streamline it, we want to do that. So basically what we have right now between the state's attorneys and the attorney general's office is our parallel schedules. There's some variations on those. And because we do schedules with each individual entity, their laws are sometimes a little bit different and their requirements are sometimes a little bit different. But in terms of the action of prosecuting, we're pretty much down to a science using, Vermont class to say, okay, if you're in this role of prosecuting, we know exactly what sets of records or types of records are always coming in. And now we're going to see if we can try to find some uniformity between the two. And we'll also flag statutes that might cause conflicts and so forth. The Defender General has not gone through the scheduling process. They're also a little different in the sense it's representation, right? It's representation of a client, which is a different kind of component than being in a setting of that nature. So, right now, and this is where the complication of this not having the right technologies, right? I don't think the bill is about a policy decision on what kinds of the misdemeanors are inclusive or exclusive from the stealing or expungement kind of realm. And that is going through a petition process, and there is a judge to kind of weigh on that part, which I think is really helpful component for it. But when it comes to the ability to actually just manage day to day, one of the things that's come up with, for example, with law enforcement is that they don't know the outcome of the case. to really for those cases that have advanced into, a commencement of a prosecution, a continuation process for that, and it's kind of sitting on these retention, because the retention has a trigger that needs to start first. We have to be kind of complete with the process. And the appeal process is a continuation, right? So it's not actually complete. So we really can't even talk about retention in general until we know there's a finite, conclusion to that particular activity with wherever that scope. So in terms of a case, that case is kind of closed. Then we have to look at all the legal requirements and obligations around that particular file that may or may not be just that one entity's, but somebody else's, responsibility to have access. And when we pull these laws together and we run the queries, like I ran it for misdemeanors in our system, which is hard because I can't really show you on paper what that really looks like. But if I type in misdemeanors and the schedules that we've issued and just say, show me all the statutes, and then show me at the same time all the other entities that have some role in that particular statute that may or may not be, and it was like 8 pages long printed. I mean, with each line being a statute. So that's why we look at intersections. That's why we look at trying to streamline it and make it easier. And then the feedback, can go to the legislature too. Like, here's a conflict. Here's where there's 2 definitions where I go to this agency and they're talking about this definition, but it makes more sense. And this definition's in a different section. And you can see here that among the attorneys, if you're looking at page 4, felonies is just a gigantic non-defined area. And misdemeanors are just everything that's not a felony. And the statute doesn't change, I think, since 1971. So when we're working through this and other sets of statutes, looking at probation and parole, and so the state's attorney were really starting to gravitate finding this definition of nonviolent felonies because it had scope around it related to ballistic crimes, as well as the exploitation of children and holding kind of like some separation on things that would be more violent felonies. And so everyone gravitated then to this violent felonies term and definition that was sitting in all places, Title 18, health and then it was repealed. So we have a little bit gap of definitions, but you can see what we're trying to do is really take every single legal requirement, because that is important. This is compliance. We spend, and you spend, every January through May hearing a lot of testimony and a lot of discussion about records, access, use, who has what, when, how, and those are your compliance requirements. And so we try to pull that in together for a management, practice, and then retention and disposition can come from that. And disposition can be meaning coming into the archives. And we have a scope around archival records, which I have in a different attachment than the last, but we'll tell you is things of statewide significance or something about someone's personal rights. As a state, we're more actively involved in people's rights, whether it's property, rights of real property, rights to their identity. And there's also rights to what happened to them in the past and what the state's role was in that. So there's many different land use rights. And then we look at historical significance, what actually prompted something for the legislature to define a change that needed to happen. And so when we look at the cases that come forward, there's a clause in there that you'll see is unless it meets the criteria of this, it has prompted some significant legislative change to improve. And those records that are related to that are then there because as a state, we do want to learn from the past. And so we'll put a part around that. So policy decisions into. So I don't know if that was way more than you're probably looking for, but hopefully provide actually context about how this process works and also that we can all collaborate together to make it work better.
Right. So no, it was helpful. That is a lot of information on there. And but I do want to ask just one more specific question then is, all right, so you've worked with state's attorneys, they have a
They have record schedules.
record schedule. Does that mean from what I'm looking at here that, I'm looking at your page 4 of that.
These are just examples.
Second.
Yeah.
Yeah, it's just an example, but so does their schedule require them to delete inactive misdemeanor documents related to misdemeanors
So
after 6 years?
misdemeanors right now set at once the case is closed, and then it and there's no further action on that. And then between the two different ones, there's a component of how they describe sentencing. So we do defer to how the agency or department wants to describe, like making sure the sentencing has elapsed, like essentially the sentencing is over. Misdemeanors are set for destruction right now after the time frame. I didn't put the specifics in there to show you like a snapshot of it, because I feel like this, at least it's summarizing that. And right now that 6 years tends to be where a lot of folks kind of tend to go towards the statutory limitations for civil action on that. So right now they are set for misdemeanors, for example, at a 6 years once closed. And the Attorney General's office is pretty much parallel to that. I don't think there's a lot, maybe they still have the provision if something meets the criteria of significant or major, they can hold that record aside for that. And it's kind of the same for the felonies as well to an extent. But those cases will be much longer based on the sentencing. So the time frame will be much later, and those records will move into inactivity faster for that agency and department, perhaps misdemeanors. So, some of there's a flag in here that I have is that by the time someone might petition on something, the records may have, as long as the records management processes are working correctly within the technologies are working, they're not always able to execute destruction. If it's in the paper-based and it's in our state record center, which we operate, we don't own the records in the record center. We're operating in active storage, but meeting those records, they will get a notice when records are eligible for destruction. You'll say it's met retention requirement. They have 30 days to decide if there's something that they need to pull back. Or otherwise they go out for destruction. In the electronic world, I haven't seen any systems built yet with records management functionality to do retention and disposition.
Interesting. Okay. So I mean, what I'm trying to just understand is kind of the background that's happening, even when we're doing expungement or sealing, that, are some of these records are on their way to being destroyed in and of themselves. And presumably, so if you could walk, do you have a question and I can tell that you?
Well, I think I just can't tell because I'm new to the committee and to the legislature, so I missed a lot of the discussion around sealing and expungement that's been happening. So I don't know if this has all been sort of explained and answered before, but I think it would be very helpful for me if maybe we just took like like we gave an example and we just like walked it through the schedule. So like, let's say we have like a misdemeanor and it's one that would be eligible for sealing under S12, and walk it from, and let's say it gets investigated and charged and adjudicated and just like walk it through to the, that would be really helpful.
Yeah, so I mean, let's just say state's attorney's office, right? So they're actively up to the point of that case going, right? They've collected a lot of records. Now there's just more records that are happening during the cases.
Yep. Discovery, all the stuff.
All this other stuff is happening, and they're building a whole case file, and they're managing everything that they're creating, receiving as part of that process.
And this is all electronic.
Well, they can tell you for sure. I mean, it's probably a combination of different paper and electronic, and what they're doing with that. There's many different ways that people might make a decision to just go paper or just go electronic. But either way, reformat's kind of irrelevant for retention. So what the schedule is doing is it's itemizing all the different types of records that are coming in there, because there might be some things after the case is disposed, they could maybe clear out. Notices, things are just, procedural for the time that court is operating, because that helps with storage situations, especially, it just helps with making things smaller and making things more succinct for the next stage. So this would basically say, and this is, what has been established, is that the case has to be closed. And the sentencing has to have lapsed for that individual. So that like they basically have to be done with their sentence from that misdemeanor and has to be satisfied. Because there's all these other laws that get involved, right, during the course that somebody is actually,
Yeah, someone's on
Filling their
probation
term,
and
yeah.
they violate probation, then it would, that violation of probation.
right. So
probably
there
would
needs to
go
be
into-
no other further actions that the state's attorney's office would ever have to do in that case. And no other legal provision that would require the state's attorney's office to have to do something in that case to be considered completed closed,
Okay,
right? So those vary based on case, right? So the way that we write the schedule is just, it has to meet all these requirements to meet the criteria of completed closed. Does that make sense?
so, okay, so now we're there.
So now we're there.
Okay.
So
and that's
then,
like,
yeah,
that could
so
be
then
a
we
whole
call,
different.
yeah, so we
when that
called
is.
out the retention trigger, right? It's basically like, now it's finite, like now you have a complete concise, there'll be something we didn't know between that, the schedule will authorize that, but otherwise you are now complete set. And then the question comes up is how long after that does the state's attorney's office have to actually legally have custody of that record for other purposes? Sometimes it's based on, and I don't know what it comes up in this particular example, but we also look for just, recent memory and active use, internally. Usually it's a 36-month kind of time frame. With these sets of records, on average, the attorneys would like to see a 6-year minimum because of any possibility of civil action against actually the office, right? So it's the statutory limitations of civil action is really where this comfort zone. So they've streamlined on 6 years. So 6 years happens misdemeanor and it's eligible for destruction.
Okay,
It's authorized for destruction. I mean, there's going to be registers, this is not the court file.
yes, okay,
So keep that in mind. It's not necessary their case management to know a case existed. But that is the eligibility component as a minimum retention requirement and authorization for destruction. I can tell you that before we did the schedule, the state's attorney's office was 6 years, because we had predecessors, was 6 years from the time the case was closed, all records.
Mhm.
And the judiciary now is it, meaning that the records are being destroyed 6 years after the case closed, no matter what kind of case it was. That's the authorization they sought from our predecessors.
This is the court you're talking about. Sure.
Yeah, this is the state's attorney's office. So for some locations and some offices in some counties, we will not have necessarily, as a state, case files that are like within this one. We issued this one in 2013 as a start based on laws at that time with the state's attorney's office. And then amended it in 2022 with the state's attorney's office for their schedules based on updated laws at that time. But for misdemeanors, that is the current. It doesn't mean we basically were all in agreement that at least for their file and their role in that is the minimum retention requirement. And this is the disposition notification. It's not our permanent archival. But there's a lot of different areas of that record. Does that make sense? Or you're concerned that it's getting destroyed?
No, I know, I'm concerned about it.
Well, don't worry, because I'm like,
No, I
we're
think
allowed
I'm
to
just-
not overkeep things that we don't need to, but also know this is just one set of records,
Of
right?
course, yeah, I'm just trying to understand what we're sealing.
Yeah, I guess the other question or two questions, but Karen's first, then go ahead, Karen.
I'm remembering us
Yeah.
having this conversation.
Yeah, I'm sure.
And it's, this piece of that you are managing the kind of like the general state documents that we have. There's still the court files that exist and they could be on different schedules.
They will be. So
Yeah.
each schedule is issued to each entity based on their own specific laws, but some of those laws are on many different schedules.
Yes.
Yes.
And because this was what really got me to the sealing piece of it, because basically I remember here, like, it's just very difficult to expunge and get rid of everything. Like there is going to be some kind of paper trail or record of things, and that Europe controls these
parameters of it, but there still probably are indexes of the crimes that have been committed. Like there is a way to track it. It's just this kind of huge pool of the paperwork is saying that it can get done. And I remember my piece too being like, so you're doing that work to manage the pile of paperwork as much as possible, but who also has access? I think that was the thing that
I think that gets to your question, why are
Yeah.
we sealing and we also running, so retention is just always going to run. That's just basic management controls. When it comes to the sealing and expungement components, it's about public accessibility and then also narrowing that confidentiality within the agency or department. So what we see is aligning and thinking about it within the context of a public records exemption, right? It's exempt from public inspection and copying, and additionally, it's just no records found. And that's an access point. So even if the records were still existing, right? Because they haven't been eligible for destruction yet, they're not meeting that, but there's a sealing order on those. And I think we just I'd have to double check within the laws of being like, when can actually someone petition? Because if they're end of the sentence and that has lapsed, and we're really talking about a 6-year window potentially. But either way, the public accessibility part is what you're trying to get to as well, and no record found. So that's an access piece. That's where on our schedules we do retention and disposition, but we also, this is a flag to say these statutes apply, and there's an access component related to security around that record. So we would do information management controls on security. Because security is how we manage who has access at what time within systems and manual or paper. But also having that, it is non-public access with an additional layer of no record found. And then the expungement component is this idea of literary, like completely destroying, and there's no evidence of that, which really is difficult to do. And so I do have, one of the recommendations that I have towards the end of the testimony is just, we do as a pun, like stepping out of the box, think out of the box on that is, we have some areas in the state where there's some natural ways to control that in terms of public, access in general. So just starting with the public is starting to think about what could be a single entity point of entry for request, because that knowledge of knowing something sealed or expunged is enough to at least say no record found and the request doesn't go forward, right? But if there is a record found, then the request can go forward to the actual custodian the request is being made from. From experience, we do see custodians sometimes like passing the buck. Meaning because there's overlap of files, so not necessarily wanting to respond to a request for their files, but redirecting someone to another set of files to use. And there's history behind that. So those are the things that, a single point of entry in 2025 with technology. And it's not to say just poop happens, but to really think about, where's the point of the understanding that there's a sealing and expungement order happening. We have the Vermont Criminal Information Center, which is not to say that that's where, but that is kind of considered to be the source of truth for actual conviction records. How can these components be leveraged in some way to say, okay, if you're looking for a criminal record, there's one point of entry if you're a member of the public, and you're immediately getting that no record found. It may be a notice then right to the agency, your records are requested, these are sealed. If they haven't sealed them or haven't made provisions or weren't notified, that's a great other way of doing that. So there's a lot of ways to innovate and talk about it, that if there's discussions happening within the state about that, I'm not involved. And it's not to say they have to involve me, but I love these kinds of discussions because this is where we get to meeting that. But does that help, I think, answer the both? Because we do manage records on behalf of entities that store, and those are paper and analog records in the state record center. Expungements has probably been the most challenging, particularly with the judiciary. Last year, and I think we're not done. If you've been to our facility, it is a warehouse, and people have managed in different courts have managed things in different ways. So finding a single docket number or knowing that there's a single charge on one piece that gets expunged.
Yeah.
But not the whole case file. We've had to make, decisions on, sealing in place And we can't necessarily expunge. It might be on microfilm. It could be, I mean, a hearing would hear multiple cases and be on a cassette tape. You can't splice or dice those any way you try. And being able to work with the judiciary and say, you do have to use your index, and everyone understands. But the concern that a lot of people have is not meeting the conditions of what the legislature expected. And this is, I think, why there's benefit to having me here to talk about those. And also just for the public's perception that we can't obliterate everything, even if it is expunged. We have newspapers, things were published, people's memories. It's really about what that conviction record might be and public perception that it's kind of okay to have had. I mean, driving too fast used to be an offense, and then it used to be crime in the state, right? When you got a speeding ticket, you were still in the criminal law for that in the past.
So how does sealing differ than expungement? How would sealing, or how does sealing?
Okay, so expungement is total destruction of the record and all evidence of that. I can tell you where we've seen, so it is destroyed. There shall be no other information. In court docket books that we're getting, or recording books, we have literally seen cutouts of the books themselves to try to do an expungement to meet that condition. Sealing, on the other hand, just from a paper based in the past, someone would put some type of seal around it. I mean, it's what it's kind of meant to be historical. Those are historical, expunged from the record and seal from the, nowadays, I've seen many people try different things of trying to do. So one of the parts of the executive branch related to sealing is trying to find all the records, whether paper or digital, and kind of find a place in their file share to move them all there to say it's sealed and it's here in some secret spot. But that's a lot of labor intensive work on that to do that, when we could be using data and information to just say the records found and then different controls for it. So people are trying to physically still operate, automate some type of paper processes because they know in the past they used to put in an envelope and inside a box. And in the judiciary, we have records that are coming that are sealed into the state archives now. It's the largest kind of contributor to legal custody. We're taking legal custody of court records and working with the judiciary to understand, what is sealed, what is expunged. But over time, if it's a permanent record of the state or something that's bound in something that's like a docket book or recording book, we're not going to pull out pages. And we have an expectation that after a period of time, the sealing and privacy components really do kind of go away as time passes. And we do use for the state archives the HIPAA Privacy Act benchmark, because if it's good for medical records, it's pretty good for understanding. I mean, right now, grand jury dockets are, exempt from public access and inspection. But do we care about 1850 or 1900 grand jury dockets for the protection of the individuals on the grand jury? Probably not, but it's very informative for people who are doing legal research or people doing historical research. And
Tom and Barbara.
I'm curious about the recordings in the courtroom. Are those kept indefinitely or in whole, or do you have to a section regarding the expunged case or sealed case?
so all the expungements for the judiciary when they're in the judiciary's custody is done by the judiciary, but if it's stored in a paper or analog format, then our team will be involved in finding and locating it. But we're really clear that we won't do the expungements because we feel it's a court function and responsibility. I do know for different times, so their current is on the server base, but there had been for a long period of time, it was by the courtroom at that, so it was just continuous recording. And so in the past, there's been different retention requirements. The judiciary, we do work in collaboration with them to issue schedules. So they're jointly issued by the Vermont Judiciary and the Vermont State Archives and Records Administration, because we provide that information management support to them. They would be using more that no record exists component for anything that's commingled to the point where you can't do anything with it differently. And there is a retention requirement but it's a very old disposition order that was like 23 years for this. And they're still operating on parts of that right now until we can work with them electronically. But I think the thing is like how recordings and written information happens there. And it's also going to be individuals might be named in other sets of records. Just keep that in mind too, that that does happen. You might have two cases that are completely intersected, but two different two different separate trials, so to speak, in cases, and there may be references in one case to the other individual, and that person might get an expungement, but the other person doesn't, and you can redact names, but there's a lot to it to know exactly where that information might be found.
So that kind of apply to like, the weekly court docket as well. I mean, because that's gonna have a schedule and it's all commingled.
Yeah.
Does anybody still do annual stenography? I mean, there has been up until fairly recently. I don't know when.
I haven't seen, but that I wouldn't be the best person to answer that right now because a lot of our work with the judiciary is based on a lot of people process and coordination around technology. We do a lot of requests for reconstituting files from microfilm for them. And I guess that's the other part, just be aware is, when there's a request, when the petition comes in for the judiciary, that is sometimes requesting to actually bring the whole case file back and to start that process, depending on what the law is, to make a decision on sealing and expungement. And that is based on time frame of very joint collaboration between the Vermont State Archives and Records Administration and the judiciary to get that file out of inactive storage, if it's paper or analog based, and back to the judiciary. And how to do that efficiently and so forth. But we do try to keep arm's length from it. If it's not in our custody, legal custody, we don't own it as the Secretary of State and State Archives, to really let, to defer to what services they would like from us and how they'd like us to help. I don't know, does that answer or help?
I'm wondering what happens, like what's the procedure if somebody's not compliant with this in particular, but just in general, like does some notification go to anyone? Like,
so do you mean within the statutes right now or our role related? Because we don't want to receive sealing and expungement notices unless they're records that we own. And part of the state archives. But I think your question is
bigger, I guess.
Yeah, and I've been thinking about that because it's I think it gets to, and there's a page on page 3 in here that talks about this kind of unified governance component that really has to happen, and we can do it statewide and we can do it internally, is the legislature is here many, many months out of a session doing a lot, and most of the acts are all based on, which entity, which function, and it's all about records. And, I can take this current draft and just parse that out in a visual that shows what that looks like. I think defining for the public access piece and thinking about ways that we could streamline that and make that really, because we want to optimize everyone's success. It's not that somebody necessarily does not want to be successful in this.
Yeah.
And I think you also want to identify when people are choosing not to. And I think that's the harder part when we have a lot of ad hoc processes and informal and not really working well for the day-to-day. It's very hard to find when there is a bad actor component, or there's other things that put us into risk as a state. So we do want to optimize.
So what I was thinking about is many years ago, we had the state auditor come into the committee and he was sharing with us, I don't even remember what bill it was, but he was sharing with us that every year when a department is getting audited, if there were findings, no, the legislature was not getting those findings, and often the next year there would be an extra audit charge for the department not dealing with the findings, which was really interesting. I mean, so I'm just thinking about that.
I've been thinking about that as well. And so it also relates to the auditor and maybe some other bills where you have government accountability. And we also have the joint fiscal office. And so some of the things that we do is, operationally when we're Vermont State Archive, like we have operations like that. I have the director hat, like we have day-to-day operations that we do. But also thinking that maybe emphasizing, starting with the legislature, that information management piece, because I think that gets to your question. And if there was a breakout, something comparable to joint fiscal, that's kind of joint, whatever, information governance, right? That I think gets to that government accountability and transparency question, but in a more meaningful way, because, we see it all day long. But how to even bring it to the attention in a meaningful way to the legislature without saying it's punitive, right?
Right.
There's gaps on this. There's a lot of different ways we could do better. But how do we bring that visibility? And it might be that it is actually good for something to be set up within the legislature with this capability or these tools, rather than a very specific branch per se when it comes to like executive branch. So I have thoughts on that I could share, but
All right,
I can follow up later
Yeah.
like that, but.
Because again, like this bill makes me think about the ramifications
Right.
and what that means. And, when can people count on the law being what we passed? And I know we are trying to also look at when are laws implemented and when are they not? And sometimes they're not because there aren't resources. And anyway, so yeah, it does.
Well, you want to know, but you also want to know it's capable, and you do want to know that there aren't what's within the statute that are actually making it more difficult for individuals to carry out what you want.
As you said, it's not always like often, probably not bad intent.
And you, quick question and a quick answer.
Yes, very quick question. Single point of entry access for public on records, you were proposing that as like.
I was thinking that could be something that could be considered.
Just to get it, my very quick question is, we're talking about where to send orders of sealing, like which agencies and departments and things to send these to, and which ones to have automatically and which ones to sort of put on the petitioner to inform the court. Could this single point of entry entity be somebody that we could send the notice of sealing to?
I think it's up for discussion. I mean, that to me is like, that's the core part, right? Bringing the right collaborators around the table to think about what could be most efficient to meet the desires of what this bill is trying to achieve, but also to relieve the burdensome of, what's really just paper entity. And that's come up with Public Records Act in general, but this to me might be a really good facilitating component for it.
You may have to explore that a little bit further.
Yeah.
So, well, thank you very much for the
Thank you for
testimony. That was
having
very,
me.
very helpful. Get us so I did have one last thing is, could you get us the record retention schedule, the record
They're
schedule?
published on our
for-
website, so I can send them.
Yeah, if you could send the link for that and the Department of State's attorneys and courts, just to have an idea, and the Attorney General.
Yeah, I'll send the ones that are related to intersect with this bill that we, and just keep in mind, it's based on those entities coming to us and wanting that service.
Right.
Otherwise, they run off of different orders that were issued prior to 2008. Would you like those two to know?
Which is
Before record schedules were in the law for 2008 and were created, there was a disposition order functionality from 1937.
just the what's current.
Current.
Yeah.
Okay.
Great. Thank you so much for your time.
All right. Thank you so much for the invitation.
Thank you. Thank you.
We're gonna turn to a walkthrough of H98, and then we can take a short break after Eric walks through
Is this on?
the amendment. So this is coming over, this came over from the Senate. This is H98 confirmatory adoption, which we sent over to the Senate. My understanding, and Eric can confirm this, is that part of this, which Michelle is our legislative counsel on, didn't have any changes, but what has been changed is the addition of section 2, or section 2 on, I guess I should say, and that's within Eric's purview. So from Eric on walking approved. So thank you for being here.
Yes, thank you. Good morning, everybody.
Welcome.
Thank you much. Eric Fitzpatrick with the Office of Legislative Counsel. Here, as the chair said, to do a walkthrough with the committee of the Senate's proposed amendment to H-98, which you may recall was an act relating to confirmatory adoptions. And as the chair said, that portion of the bill, which is section 1, is identical to what passed the House. So there's been literally not a word change to that section of the bill. Remember, that involved this expedited process in the probate division to create confirmatory adoptions for children when their parents are already legally parents under Vermont law. And what the proposal from the Senate does is it adds another expedited proceeding in the probate division. So there's your connection between the two things, adds another accelerated, expedited opportunity in the probate division for a separate type of proceeding. All of that is new language to the House, because section 1's the same as what you passed. The next sections were added by the Senate. Originally S-95, in case you're curious. It was a Senate bill that was on the wall downstairs, and the Senate Judiciary Committee also happened to involve an expedited proceeding in the probate division involving children. So what the Senate did was attach that one to H-98. And so, as I say, it's a consensual guardianship situation. In other words, it's not one where somebody is opposing the establishment of the guardianship. I'm just going to talk for a minute or two about the big picture before we're looking at the language. And the probate division has jurisdiction already over consensual guardianships. And there are a number of circumstances where consensual guardianships can be established. And it's a situation where both the custodial parents and the proposed guardian are all in agreement that the establishment of a guardianship is in the best interest of the child. So it's not an adversarial situation. It's one where the parties have all agreed that that's the best move. And when that's the case, the proposed custodial parents and the custodial parents and the proposed guardian have to execute an agreement in writing, bring it into the probate court. And if the probate court agrees with the agreement that the establishment of the guardianship is in the best interest of the child, then they order that it adds one more circumstance. You'll see, well, look, there's a list of statutory situations where this consensual guardianships can be established. And this adds one more to that list. And that addition to the list is what I mentioned, is known as a standby guardianship. And that's a situation where the parents of the child are unavailable because of what's defined, and we'll get to this term, an adverse immigration action. And what that means is that the parents of the child have become unavailable to care for the child. And we'll look at the definition, but for purposes of the big picture discussion, just think of it as because they were detained by federal immigration authorities. Just think it. We'll look at that more specifically, but that's sort of a general description. They've been taken into custody for an alleged violation of federal immigration law. So in that situation, the proposal is if you think of whether or not there's a guardianship or not, if there's not a guardianship, the way the legal consequences of the parents being taken into custody could be that the child would end up in state custody, Department for Children and Families, if there's not a guardian designated. So the idea of the custodial guardianship is that it permits the custodial parents and the proposed guardian to reach this agreement and file the agreement and the petition for the guardianship with the probate court. And that way, instead of going to state custody, the child can go into the custody of whoever their chosen guardian is. That's the big picture idea. The expedited nature of it, because that's also a factor, is that ordinarily these custodial guardianship proceedings require that notice be provided to any interested party and to other parents. Also requires that a hearing take place before the guardianship is ordinarily. Also in existing statute, there's emergency circumstances where the court is permitted to waive those requirements. So this standby guardianship situation is also added to those lists. So in other words, you'll see when we look at the language, oh, here's some situations under existing law where in an emergency, the court can waive those hearing and notice requirements. This adds this standby guardianship situation to that list as well. The idea is that the the custodial parents and the proposed guardian can execute these documents in advance so that if the custodial parents do end up being taken into custody, the guardian or the children's attorney can go down to the probate division, file the documents that have already been executed, and rather than going into DCF custody, the kid could go into the custody of the proposed guardians. So that's the big picture. And the first part of the bill is unchanged, so I would probably just, and we can look at that if you want. I didn't draft that, but I could.
You just jump to the.
Yeah, that makes sense. Okay,
Spent lots of time in confirmatory document.
And that hasn't changed at all.
not at all. No, same as you passed it.
Just a clarifying question.
Yeah.
Question, Eric. The adverse immigration action,
Yes.
that's the section that we're getting into in section,
Mhm.
that's section 2. Okay.
Exactly. Well, section 2 and several and the
And beyond, and beyond.
beyond,
Yeah,
exactly.
yes. Okay.
So that does begin on bottom of page 5. And so we're now in the guardianship chapter of Title 14. This is what we're looking at. And as I said, the consensual guardianship is what's being amended here. So you have this existing process in the probate division for consensual guardianship. That's when the parties agree that a guardianship is in the best interest of the child. And so the question that you might ask yourself is, well, when can those be established? What are the circumstances under which a consensual guardianship can be established? That begins, it starts very bottom, last line of page 5, but it's really on page 6. Child in need of guardianship means, and then you turn over onto the top of page 6, and you see subdivision A there, a child who the parties consent, right? That's the key. This is a consensual guardianship definition. A child who the parties consent is in need of adult care because of any one of the following. And so the existing circumstances you'll see are Roman numerals 1 through 5, lines 3 through 9. And so these are situations under current law where this consensual guardianship can be ordered by the court. So for example, subdivision 1, child's custodial parent has a serious or terminal illness. 2, or the parent is physical or mental health prevents the parent from providing proper care and supervision. Child's home is no longer habitable as a result of a natural disaster. A custodial parent is incarcerated, or a custodial parent of the child is on active military duty. So you think of those, they're all, with the exception of 3, which is a little bit different about the habitability of the home. The other 4 involve the availability of the parent, right? For some reason, in each of those situations, the parent is unavailable. So that's what's the proposal in, I was going to say S95, it's H98 now, but S95 as it's folded into H98. In subdivision 6 there is to add another circumstance under which this consensual guardianship could be ordered. And in this case, it's when a custodial parent of the child is unavailable to care for the child because the parent has been subject to an adverse immigration act. And so it adds one more circumstance to this list of situations where a non-consensual guardianship can be ordered by the court. And note that it's, oh, sorry, go ahead.
Sorry, Eric, I don't mean to interrupt.
No,
So
please.
I actually have a question on line 9 for active military duty.
Yes.
So again, this is just a hypothetical, but say there's an active duty parent who's deployed abroad and whether it's the mother or father and the other parent is no longer in the picture, the child is staying in the guardianship of grandparents here in Vermont. God forbid something happens to the active duty military person who's been deployed. This would essentially create a provision where the grandparents of the child could take custody. My thing is assuming that one of the parents is out of the picture for one reason or
Right,
another, and
right.
the other is something tragic happens.
Yeah.
Like, how does that play out in this legislation?
Well, that one in particular, line 9, as you're talking about, that one happens to be existing law. That one,
Right.
that's not new. But so the process of that, yeah, would be very similar, that there's an opportunity here under the existing law for the grandparents to become guardians of the child. And in fact, one of the, as I was mentioning, the existing law also provides, although generally notice and hearing and those sorts of things are required, notice to the parents, that sort of thing, there are lists of exceptions when notice doesn't have to be provided. And one of them, as you say, something tragic happens. One of those things is the parents are dead.
Yeah.
And if that happens and no notice is required, and there'd be an opportunity to, assuming the grandparents were willing, you could do a consensual guardianship. for the children in that situation. But that's existing also.
Yeah, right. But I think, so I want to understand, like, if there are active guardians, maybe not caught, like, maybe not in the eyes of the court, but they're looking to do some kind of action there, but it ties into kind of what I'm going to get at with the adverse immigration action, but I'll save that question for as we continue on.
Okay. Sounds good. So the next, so we're still in the definition section. So that, as I was mentioning, it's adding this adverse immigration action to the situation where a consensual guardianship can be requested and obtained. And it's known as a standby guardianship, and that term is defined over on the bottom of page 7. New definition 8, you see. So standby guardianship means a consensual guardianship, as we've been talking about. Consensual guardianship agreement between the custodial parent and the chosen guardian. So the guardian is the person whom they identify and choose, that meets the requirements of section 2628 of this 2626A of this title, which is the new section that's being added. So we'll get to that and go through it. But that's essentially the procedural requirements of establishing this custodial guardianship. So we'll get to that in a moment.
Eric, just a question about how this is drafted, I guess. I'm noticing that it's consistently parent singular. I'm just wondering.
That came up during the discussion, so I'm going to defer to your witnesses on that question. They have an experience with guardianships in practice, much more so than I do. But that exact question was discussed, and we were wondering whether it should be singular or plural. And so I'm going to defer to the witnesses on that one. So nice catch, though.
Curious.
Yeah. All right. So yeah. So this definition of standby guardianship. So when does it? It's when this guardianship agreement that meets the procedural requirements in which the custodial parent has, and then we're going over to page 8,
Yep,
has been subject to an adverse immigration action that has rendered the parent unavailable to care for their child. Now, remember, note here too that it's not any time that the parent has been subject to an adverse immigration action. There has to be causation there. Subject to an adverse immigration that has rendered the parent unavailable to care for the child. So they have to have been has to have caused the parent to be unavailable to care for their child. So that's the circumstance under which a custodial guardianship could be requested in this situation.
Sorry, before you jump in there.
Yes.
I just want to make sure that I understand the landscape here.
Right.
This is for children that, regardless of immigration status.
For the children.
Right.
Yes, exactly.
Like, so whether they are here, whether they were born here in the country or if they are here illegally.
Yes.
It's regardless of status.
For the child situation.
For the child situation.
Exactly. Right.
Is there federal law that would preclude this from happening?
I'm not aware of any. No, I don't think first it was with respect to the child, because it's establishment of in most circumstances, temporary guardianship.
Right.
Until the parent situation is resolved. And they may end up, as you'll see kind of later on, it may end up that the parents end up being removed outside the country, in which case the children may join them. That's a possibility that the legislation accounts for.
And I think that that's something that we've obviously seen at the federal level with the federal administration, making sure that, children, if the parents are being deported, that the children there's optionality for the children to go with them.
Right.
I guess my question is, and like, this is maybe more policy, so you can tell me, Zach, this is policy. But I think of often like many immigrants that could be in our community, and maybe they lack the family infrastructure. Like maybe they're here alone, maybe they're here chasing a dream and trying to make things work. Like, how would that work if there's no direct family ties?
You mean like no person who could be a proposed guardian?
Right, exactly.
For example.
Well, I just wonder if it's ripe for abuse, where people come in and take guardianship for the wrong reasons.
Oh, I see what you mean.
And it could put a child in a very dangerous circumstance.
Yeah. Well, and admittedly, no human structure is without possibility for abuse. But having said that, the court does have to make a specific finding that the guardians that is in the best interest of the child. So is that infallible? No, but it's in some ways checked.
There are checks. Yeah.
Right.
Checks.
Yeah.
Yeah, Ken, go ahead.
What we're dealing with here with this immigration stuff has been going on for years though, correct? I mean, this might be new language for lack of better words, but this immigration situation has been going on for years. And we've been dealing with it somehow with some sort of language, right?
Well, it's an interesting question. My understanding, and I think the witnesses will be able to offer some more context for that question. But for example, I would say, first of all, it seems to be sort of anecdotally that it's happening more frequently now. So that, in other words, the problem is kind of percolated to the surface a bit more. But whether or not that's even true, there's a question of whether or not under the existing statute, and it's funny, it helps me because I had neglected to mention this. If you turn back for a moment to page 6, lines 12 and 13, and this was the list of circumstances where the court could do this now, as you were saying, Representative Gosselin, that does the court have the ability to do this now, for example, in this situation, an immigration situation? There is this catch-all language, lines 12 and 13. And in other words, we went through the specific situations. There is some catch-all language where the parties have articulated and agreed to another reason that guardianship is in the best interest of the child. However, I think there's been some lack of clarity and disagreement as to whether is that really clear enough? And some courts have maybe said maybe, and others have said maybe not. So that's why, yes, has this existed? Probably has. But I think the nature of current events has led some folks to think we should be more specific. If it's a policy matter, you decide you want to have this as an option, at least make it clear so that there isn't ambiguity as to whether or not it can be done or not. Does that respond?
I'll wait for the witnesses.
Okay, yeah, you bet. So let's look at, so now we've gotten to the definition of, so obvious question, given the sort of proposed structure here, well, what is an adverse immigration action? And as I said, I think that's over on page 8, starts on line 3. And so it's any one of these, you'll see that it goes A through F, so that's 6. So it's any one of these 6 actions, remember, if it causes the parent to be unavailable to care for the child. It's not just that it happens, period. It has to happen, and as a result, the parent's unavailable to care for their child. And again, remember, the issue here, interesting, it's sort of different than some of the other immigration-related issues that this committee and other committees have been dealing with. It's different than those in the sense that the only issue here is whether or not the action happened. It's not whether it was proper, whether it was improper, whether it was good cause or bad cause, or whether one agrees with it or doesn't agree with it. It's not relevant to this particular bill. This only question is, did it happen? Yes or no? And if it did, and as a result of it, the parent's unavailable to care for the child, then the petition for the guardianship can be filed. And as Representative Harvey was saying, it doesn't mean that it's necessarily going to be granted. Court first has to make findings that, oh, okay, there's an appropriate guardian, and it was entered voluntarily. We see the signed documents, that sort of thing. That process has to happen first, but there's not a question about sort of the underlying policy of whether or not these actions are wise or unwise. It's just whether did it happen.
Sorry, just and another follow-up, Eric. There's no requirement for a familial relation. Like this could be
The proposed guardian.
right.
Could be whoever. Now they do have to agree. But no,
Right, there has to be consent. There's no provision that says it has to be a family member.
Correct. Yep. Could be, but doesn't have to be.
Right.
Would we, right,
Go ahead, sir.
would we have to require or find, if the parent is actually the parent of the child, how do we even substantiate that?
Well, it's a requirement that the custodial parent be the person who has custody of the child. But as far as, whether that's how that's substantiated in the probate division, I think I'm not aware of how that works in practice, but maybe your witnesses could provide you some information on that. I don't practice in the courts right now, so I'm not sure if a question comes up as to, well, is this parent an actual parent? What sorts of proof do they bring in to dispute that? It's a good question. I don't really have the answers, but I'll bet some of your witnesses would. All right, so though that list of adverse immigration actions, as I said, it's fairly self-explanatory, and we can go through it. But again, the question isn't really whether it's wise or unwise, did it happen or not. So the first one is this is action to the parent, by the way. That's the idea. Arrest or apprehension by any federal law enforcement officer for an alleged violation of federal immigration law, perhaps the most self-explanatory one. Arrest, detention, or custody by Homeland Security or a federal, state, or local agency authorized for acting on behalf of Homeland Security for an alleged violation of federal immigration law. So again, it's just parent being it happened or what are the circumstances? That's not the issue here. That's not the it happened or what are the circumstances? That's not the issue here. That's not that hasn't been discussed, as you well know, in other communities for other reasons. But here, that's not the issue. Just did it happen or not? And if it does, then the petition can be filed and the court may grant it if the findings are made.
Okay. And so I guess a question that I have, Eric, is kind of looking at like this long list, which seems, quite comprehensive in subsection 9, and maybe the divergent paths between, a criminal offense and a civil offense, right? These are, constantly in the debate that we have around immigration, this is kind of one of the common themes that keeps coming up.
Yeah.
And I'm wondering if there should be different provisions in the legislation, whether there was a criminal action against the parents versus a civil, right? Like if someone's just overstaying their visa, or something like there's a denial of revocation, right? Like maybe there's a curing period, right, where the parents can kind of work out like what it looks like if the child is going to stay here. Obviously, I think there should be a citizenship aspect to this as well, and that's a whole different ballgame. But like, was that part of the consideration here? Or is it just like one of these things happens and that's it? There's no consideration whether this is a bad actor, a good actor.
It was the latter, I think. And my understanding of it was that because the focus was not so much on the conduct of the parent as it was on the child being kept out of state custody because they were then without a parent to provide care for them. So not to say that that's not a good question, and also not to say that I'm more of a policy question as to whether or not you think under what circumstances do you think this should be available. Good question, but that angle on it didn't really come up in the Senate. They were more focused on the child situation.
Sure, and I guess the question that I come back to is whether just because the parent wants the child here, is that really in the best interest of the child themselves? So that's like the policy consideration that I'm coming back to on this.
Right.
And I know that's policy.
Right.
So I'm just speaking aloud, I guess.
Sure. All right. So moving on, now we're getting into kind of the procedure here. So very bottom of page 8, but really move over at page 9. This guardianship proceeding, and this is the case in underlying law, as well as here, is it has to be initiated by a petition. So a petition has to be filed to establish a guardianship, and information that has to be included in the petition is set out over on page 9. And this is all existing law. And you see it's along this, a lot of basic identifiable information, names and address of the parents, children, proposed guardian, et cetera, proposed guardian's relationship to the child. So a long list of basic information that has to be in the petition that gets filed. So what this proposal does is it adds a couple of things to what has to be in the petition. And those are over on the top of page 10. Adds 2 things. So if the petition is seeking this standby guardianship, which is what we've been talking about, this situation where there's an adverse immigration action and the custodial parents and the proposed guardian are trying to have this child placed into a guardianship because the parents aren't available anymore, then that has to be in the petition. Has to be set out right there. That's number 11. Whether the petition seeks a standby guardianship and the reasons for the request, including the adverse immigration action. So that has to be identified as well, whatever it is that happened. And lastly, whether the petition is an emergency petition. So remember, I mentioned that this allows for expedited proceedings. That can be an emergency petition. And so that has to be stated right up front as well. So the court knows in the petition whether or not, hey, this is one of the situations where a standby guardianship is being requested, and it's alleging that there's emergency circumstances as well. Speaking of which, this subsection B that it goes on to next, this is the point that I mentioned early on that, that generally these guardianship petitions have to be served on parents and parties. Generally, you see that in lines 6 through 8. Petition for guardianship shall be served on all parties and interested persons, as provided by Rule 4. That's generally true. But starting in subdivision 2 there, line 9, those notice requirements can be waived. This is existing law. They can be waived by the court if the court finds that, and the existing bases on which the court can waive the notice requirements are Roman numeral 1 and 2 there, lines 12 and 13. If the identity of the parent is unknown or the location of the parent is unknown. So again, it's this idea that for some reason the parent is unavailable, either because they don't know who it is or they don't know where they are. So this adds another instance in which those service requirements can be waived. And that is if the custodial parent is detained as a result of an adverse immigration action and guardian and the custodial parent's attorney are unable to contact custodial parent after making reasonable efforts. So you sort of envision, well, how might this have happened? Well, if they're in custody somewhere and they can't contact them, even though they tried, well, in that case, they're not going to let that stop the guardianship from being ordered by the court, assuming all the other findings are made also. So that's another circumstance under which the court can say, all right, I'm going to waive the notice requirements because of these reasons, and we're going to proceed to the merits of the case.
Jack. Full of questions today, Aaron.
That's all right.
Going back to the emergency petition, is that defined in statute currently as to what that timeframe actually looks like? Because I'm just thinking, in the current judicial landscape that we're existing in, massive backlogs. And I understand that everything would be best intention as to try to make an emergency petition, come to the court and work it through the system as quickly as possible. But, part of me is also looking at, there's a reality that exists in the state as it currently stands. So I'm wondering if that's currently defined. Is it 14 days? Is it a month?
I don't know. That's a good question. I don't know if it's defined as to how quickly the court has to act. But interestingly, and you'll see in the emergency language, it does say that, for example, with respect to waiving the hearing, the court is supposed to have, even if they don't have the hearing beforehand, if the court does waive it, they have to have one within 3 days afterward.
Okay.
So, but it would be a good question for the judge.
Sure.
About how does that, as a practical matter, when you see something come in that says emergency, how quickly can you get to those?
And in a follow-up, as the legislation is currently written, what happens with the child in the interim, right? From the time that the parent, like some kind of adverse action has happened,
right,
to the time that the custodial agreement is reached and recognized by the courts. Like,
Mhm,
where's this
mhm.
child? Are we just allowing them to stay with the de facto guardian?
Good question. Yeah, I think the practitioners would have a good answer for that one as well. Right. That's like, because again, informed by what you hear from the court about how quickly it takes action,
Right.
then if it hasn't happened, say, the moment that the custodial parent was taken into custody, even if, let's say, they're able to get to it within a day or two, what happens during that day or two? Good question. I don't have that answer, but
Sure. I just want to make sure it wasn't in the latter pages that we're going to get to.
Right.
That I'm jumping ahead.
Right.
Thank you.
Sure. So we were just talking about, so the court can waive the notice requirements in the standby guardianship situation. That was the bottom of page 10. We're moving on to page 11 now. So now we're talking about the hearing. All right. Remember I said generally there has to be this hearing before the petition can be granted by the court and the court orders a guardianship. That's generally. So page 11 describes the general hearing procedures. But as I also mentioned, we're going to what Representative Harvey was just talking about over onto page 12, line 6. This is the emergency, and this was what was cross-referenced in the remember the items that have to be in the petition. The petition had to say whether it was an emergency petition filed pursuant to subdivision 2625F1. Well, there it is on page 12, line 6. So under the current statute, court may grant an emergency guardianship petition filed ex parte, and that's language that everyone hopefully remembers. That means from one side, from one party, an ex parte filing. So in other words, it's an action done by the court without involvement of all parties, only with the involvement of one party. And that there are various places in law where ex parte proceedings are permitted. And this is one of them. Court may grant an emergency guardianship petition, and probably goes right to your question, Representative Harvey. Well, why, policy-wise, why might that be there? Because they're in a situation where the child is without parents or without some sort of adult supervision, it makes some policy sense to have the proceeding move along as quickly as possible. So that is an existing law. The circumstances under which an existing law, the emergency guardianship petition can be granted. You look at line 10, if the court finds that both parents are deceased or medically incapacitated, and then it goes down to line 14. I'm just skipping the new stuff for the minute. The best interest of the child require that a guardian be appointed without delay and before a hearing is held. So if the court finds that, makes those findings, got to have a guardian without a delay, even before a hearing, and in both parents are either deceased or medically incapacitated. Again, it's this theme of unavailability, right? Unavailable for different reasons. So this adds the standby guardianship to that those list of permissible circumstances when the hearing can be waived if the court finds that the best interest of the child require it. And it's in the case of a standby guardianship, custodial parent has been subject to an adverse immigration action that renders the parent unavailable to care for the child. So that's the case. And the court finds that it's in the best interest of the child to move quickly without a delay, then you don't have to have the hearing beforehand. But as I mentioned, this is, you look at line 16 through 19, this was what I was mentioning, Representative Harvey. If the court does grant this emergency petition, it shall schedule a hearing as soon as practicable, that's line 18, and in no event more than 3 business days after the petition is filed. So if it does it without the hearing, got to have one very soon after. And that is a due process principle that I think we've talked about as well. If you court those kind of interests have to act as quickly as possible if there hasn't been an opportunity to appear beforehand.
This is a little more philosophical, and I just want to check my own understanding. Are there distinctions with due process between parents and children?
Distinctions in the sense of
Whether due process being afforded, the extent of which?
I think probably in the big picture, there probably are just, for example, I know in schools and things like that, but due process does apply to everybody. Depending on the circuit, it's one of these interesting concepts that I won't quote this Supreme Court decision or even be able to name, but I always remember there's this famous, due process may apply, but depending on the situation, how much process is due, so it's not an exact fit for every particular situation. It's a scale of things. Generally speaking, it's about notice and a right to be heard in front of an objective finder of fact. So it's speaking very generally, but depending on the circumstances, can the amount of process due change? Yes. But I don't think it would be, I think it's not to say that it would be not available at all.
Right.
For parents and or children.
Right. And that was just the kind of like the philosophical question that I was hoping to understand, because, when we had the joint hearing with the Senate Judiciary Committee, there was the concept of illegal entry versus legal presence. Right. And I think there's a really key distinction here between those that are here that have a legal presence versus those that have, broken US law and come here illegally, which is, obviously a federal crime. So that's just kind of like the distinction too, that I'm, like how far does due process extend? Or like how much process is due, to quote you back.
Mm-hmm.
And then also what is due to those either violating our law or whether it's a civil infraction.
Yeah. And part of it is a policy question for you is based on those factors to think about, well, how much process do you want to have due?
Yep. Yeah, right.
So one last thing before we move on from this that I just want to mention on lines, this is still on page 12, lines 7 through 8. In the case of this standby guardianship, remember I was saying the emergency petition can be filed ex parte, also provides that the child's attorney can be filed, not only the guardian, but the child's attorney. I think I mentioned that during my initial description, can also be the one who files it in an emergency situation. So again, it's envisioned a situation where the attorney, the proposed guardian, and the custodial parents have all executed these agreements beforehand. So they're all in place, ready to be filed. So this sets it up so that, hey, the attorney, they've already been executed. The attorney might well have it in their office. They could bring it down and file it if the adverse immigration action happens.
Okay, so another one. I'm just trying to anticipate intent and maybe unintended consequences. And I'm thinking of those that might be bad actors coming into the state and doing these agreements proactively. And this legislation, de facto would protect those scenarios and allow for children to stay beyond their parents, potentially being removed from the state. Am I understanding it right?
I think it's still, you still have the sort of judicial oversight that would sort of prevent that from happening ideally.
But I'm wondering, like in this hypothetical, in the interest of being expeditious within the judiciary, say these agreements are preconceived, pre-agreed upon with all the interested parties. They're presented to the court, and the court's saying, well, the parent's not here. We need to do this in an expeditious manner for the best interest of the child. You know, we need to accommodate this. Like, I guess maybe it's a question for the
Yeah,
the
it's a good
judge.
question.
Yeah,
Right? Yeah, good question for the judge, definitely.
Barbara.
So my question's a little different than Zach's. I'm wondering how this proposed legislation would apply if children who are the children of people who might be subject to an immigration violation are currently being detained along with their parents. Would it apply for them to be released to a guardian? And if so, does that matter if they are some of the times they're being held and they're citizens? So I'm wondering if this applies whether or not the children are
Not if they're being detained, no.
not if they're being
No.
detained.
But if the parents were detained, just sort of envision maybe a situation at the border, say, where the parents were the ones who detained, not the child. Then this process could be available for the child in a situation like that.
But if the child is detained with a parent, the child is a legal citizen, could the child's and parent's attorney use this law to get the child to be placed with a guardian and be released from detention?
I don't see that because I think the detention is a matter of federal law. So you couldn't take it in state law.
Okay.
Yeah.
Right, thanks.
So that brings us to as I mentioned earlier, so the new statute, this enacts 14 VSA 2626A. I should add here that 2626, the existing statute, deals with consensual guardianships generally. Now, this is adding a specific type of consensual guardianship, the standby guardianship, but much of the language is actually identical. So it's very similar to what is already in law for. And remember, we looked at those situations where consensual guardianships can be established now. That applies to those, and there's a specific one for the standby guardianship situation, basically establishing the process. And as I mentioned, a petition has to be filed. You see that in line 4. A petition has to be filed requesting the consensual standby guardianship, and it has to be accompanied by a consent form. See that? That's line 4. Consent form has to be signed by the custodial parent and attest that the custodial parent understands the nature of the guardianship and knowingly and voluntarily consents. Now you see lines 8 and 9, the court administrator is going to develop a form for this. So there'll be a form for this consent form that has to be signed and submitted with the petition. The court is timing issue here, also line 10, court has to schedule hearing within 14 days. Custodial parent can be permitted to appear and participate remotely.
Before you move on.
Yes.
So I assume the 14 days applies unless there's the ex parte emergency petition on F1.
Exactly.
Yeah,
There's an emergency petition, then there's the 3 business days.
Right.
Otherwise, 4.
Although that 3 business days is how long they have to schedule a hearing after but yes, you're right. Yes.
Right.
Yeah, exactly. But you're right. That's in that case, you've got a hearing that has to take place much sooner after the filing of the petition than this.
Okay.
Yeah. And then so you have this, remember I mentioned at the beginning that part of this consensual guardianship is that it's by agreement, right? There has to be this written agreement filed. That's addressed in lines 13 through 14, where it starts on page 13. On or before the day of the hearing, parties have to file an agreement between the proposed guardian and the custodial parents. So there's this written agreement that has to be filed. And then what goes on from there is, well, what's got to be in the agreement? Contents of the agreement are after that. So you see the list of contents, subdivision A, that the parties are creating the standby guardianship that is effective only if the custodial parent has been subject to an adverse immigration action that renders the custodial parent unavailable to care for the child. So if that hasn't happened, you can think of it as a precondition. right? Without that precondition, it's not effective. So then also in there has to be the responsibilities of the guardian, responsibilities of the parents, and this is some language that is also in the underlying custodial guardianship statute that I mentioned, same sort of information here. Expected duration of the guardianship, if known, that's top of page 14 now. Any kind of parent-child contact and parental involvement in decision-making. And lastly, that the guardianship shall presumptively terminate if the custodial parent is released from custody and reunited with the child. So that's sort of an end time there, presumptively, if the custodial parent is released from custody. And any party may notify the court that that's what happened in lines 6 and 7. Lines 8 and 9 is also language that will often be placed in probate proceedings. And this is saying that in this probate proceeding, as in many others, including consensual guardianships generally, the relaxed rules of evidence apply. It's like probate proceedings are meant to be user-friendly. I think it's one of the court proceedings that is used most often by people who are without attorneys, pro se. And so there are frequently a provision that relaxed rules of evidence apply, because a lot of times you're having non-attorneys in the probate court in particular. For many people, that's the only court in which they'll ever have an interaction with. What was that?
In the Senate, Eric, was it discussed at all for there to be a time limit or a sunset of the guardianship? Or this would be in perpetuity until the child is hopefully reunited with their parent?
There is, I misunderstood your first question. I thought you meant a sunset for the bill, but you mean for the guardianship itself.
Yes, that's right.
Yes. There is a section, we'll get to it, about termination.
Okay.
So what happened, how it terminates, who can file a motion, and that's also in existing law, but some language is added for the standby guardianship in particular. But that's also addressed by this presumptive termination that we just mentioned in line 4.
Right.
That if the parent is released from custody, then there's a presumption that it terminates right then.
Right, and I'm wondering, well, and I guess, right, that's assuming that they're released in this country or in the state. If they're released from custody in another geographic region. Right.
It's an interesting question. I'm not sure I read it that way. To me, it seems to say that wherever they're released from custody, if they're reunited from the child, if that's the case, then that would trigger the termination, or at least the presumptive termination of the guardianship.
Because
I think
I'm wondering about a clause that would assume like good faith and intent of the parent to reunite once out of custody or something. Like, is that something that we could potentially include?
Oh, yeah. I mean, I think you can.
Absent that, then I mean, absent that, my thinking is that there would be a different off ramp here. We'll get to policy.
Right.
Probably getting ahead.
But I think it's certainly language that certainly could be added.
Plausible.
Plausible.
Yeah.
Right. So we now got to, I think, subdivision line 10 of page 14. So this is all right. When does the court grant the petition? All right. We've gotten through the hearing process, what has to be in the petition, all that sort of thing. Court grants a petition, shall grant the petition if it finds after the hearing, again, generally has to be after the hearing, except for those emergency situations, by clear and convincing evidence. So this committee recognizes that language. That's the language that's more than a preponderance, but not beyond a reasonable doubt, often described as reasonably certain or highly probable, what the courts will often say they mean by the clear and convincing standard. So this is required finding by clear and convincing evidence. And you'll see we kind of have referred to some of these earlier. Subdivision 1 there, court has to find that the child is in need of guardianship because the parent has been subject to an adverse immigration action that renders the parent unavailable to care of the child. Again, there's that standard we've been seeing throughout the bill. Court has to also find, I'm in subdivision 2 now, line 15, that the custodial parents knowingly and voluntarily consented to the standby guardianship, that the guardian or the custodial parent's attorney made reasonable efforts to notify the parent. Agreement is voluntary. Proposed guardian is suitable. That's line 20. That kind of goes to one of your earlier questions, right, Harvey, about making sure that it's not someone who will be unsuitable. And lastly, that the guardianship is in the best interest of the child. So you got those requirements, findings rather, that the court has to find by clear and convincing evidence. And if it does, then it shall grant the petition in order that the guardianship be created. So we're moving over on to page 15 now. This establishes a rebuttable, oh, sorry.
No, I got a question, and I don't
Yeah.
know who it's for. And maybe it's already been talked about, but I guess why would it make it easier to separate families? And I don't even know who that question is for, but that's the way I look at it. Well, it's just bad, but
Well, this is consensual. It's voluntary.
I realize that, but we're still making it easier to separate families.
I think the idea here, and this is something I mentioned earlier, is that this only applies in a situation where the parents have been detained for immigration violation, so they're in custody. And without a guardianship, the children would end up going into DCF state custody. So the idea is rather than that option, you have an option where they can agree beforehand that there would be a designated responsible adult guardian, and they would go into that custody rather than state custody.
I apologize.
No,
I missed a lot. I took it as somebody being deported and then being separated.
Right.
Making it easier to separate them from the
Yeah.
kids. Thank you.
Yeah, no problem.
Very quick one, page 14, line 15, 16. So the child's custodial parents knowingly and voluntarily consented to the standby guardianship.
Right.
Can that be done by proxy?
I don't think so, because the parents have to sign. I'm gonna go back to the where that has to be signed. Nope, they have to be the ones, lines 4, the way I'm reading it, lines 4 and 5, page 13. The consent has to be signed by the custodial parents, attesting that they understand the nature of it and knowingly and voluntarily consent. So I'm reading that it has to be them.
So if the parents are not to be found or cannot be located, then that nullifies any potential agreement.
I think, you mean if they never signed it in the first place?
That's right.
Yeah, I think they have.
That'd be impossible.
Correct.
They have to physically sign.
Yes, they don't necessarily have to physically be there at that hearing because they might be in custody.
Right, but they have
Yes,
to
they
physically sign.
right.
Yes. Thank you.
Yeah, you bet. So, all right, so page 15. So actually, we're very close to the end. So there's also a rebuttable presumption. This is under subsection E, page 15. This means that a rebuttable presumption, you may remember, if certain facts are found, then the court is permitted to find another fact based on those facts, although it can always be rebutted by other evidence. Now, in this case, the underlying facts, if the court finds 1, 2, and 3, lines 3 through 6, that the custodial parent has been subject to the adverse immigration action and is unavailable to care for the child, all parties consented to the guardianship, right? Remember, so they must have signed that form themselves, and the custodial parent is represented by an attorney. If they find those 3 things, then the court is permitted to find based on that the guardianship is in the best interest of the child. Now, again, it's a rebuttable presumption. So if there's evidence that it isn't, then that finding could be different. The court could find that it's not in the best interest of the child if there was evidence otherwise, but it's rebutted, and that's it. Now, what if the court does grant the petition? That's on line 7. So if the court grants the petition, it shall approve the agreement and issue an order establishing the guardianship within 45 days after the petition was filed. And you see line 9, unless the court extends the time for issuing the order for good cause shown. So generally speaking, the guardianship order has to be issued within 40 days after the petition, but the court can extend that time for good cause. And that is we'll go through the rest fairly quickly because we've covered most of it here. The substance section, starting on page 15, section 6. This is purely technical, just adding, you see line 17. This is adding standby guardianship section that was just created to the list of the types of guardianship petitions that can be granted. So that's all that is. Now we go to the powers and duties of the guardian. Starts on page 16. Again, doesn't change anything about existing law until you get over to page 18. So the general powers and duties of the guardian, all this does is add something specific to the standby guardianship situation. That's on line 8, page 18, and a requirement of status reports. That's all that is. So the guardian has to provide status reports to the custodial parents and the attorneys in a standby guardianship situation. So that's all. That's just
What line was that, Eric?
That is line 8 of page 18.
Thank you.
Yep. That's the status reports requirement. Now we get to section 8, and this is the termination issue that you raised, Representative Harvey. So this is the process for terminating one of these guardianships. Now we're further down the timeline, right? It's been created. Well, how does it terminate? One of them we already looked at. Remember, it presumptively terminates if the custodial parents are released from custody. That's one way that it terminates. Here, parent may file a motion to terminate the guardianship at any time. I'm on line 14, page 18. So at any time, the parent can file this motion to terminate. And if it's line 17 and 18, if the motion to terminate is made with respect to a consensual guardianship, which this is, right? This is a type of consensual guardianship. If that's and actually, it's clarified there, the new language, if it's made with respect to a consensual guardianship or a standby guardianship, both of these are consensual, the court shall grant the motion. See, that's line 19. So if the parents file and say, we're ready to terminate, the court is required to grant it and terminate it unless the guardian files a motion to continue the guardianship within 30 days. That's existing law. And that's this idea that the reason that that's there is that in general, potential guardianship, everyone has agreed, right? The guardian, the custodial parents, everybody's on the same page. They've all agreed to it. So you get to a situation where the parents say, okay, we're ready to take custody of the child back. We're going to file a motion to terminate. What if, even though they consented at the beginning, the guardians then say, well, we don't think it should terminate. And this is not really probably going to happen in this situation, but it happens in other consensual guardianship situations. It's actually not uncommon, as this committee has talked about in other situations. So, but generally speaking, if that happens, if the guardian comes in and says, oh, no, I don't want to terminate this, then the whole proceeding gets changed into an involuntary guardianship, and all those adversarial proceedings then take place. So that's the structure that this is laid on top of. But the standby guardianship qualifies for the same one. If that doesn't happen, if the guardian doesn't say, no, keep this in place, then the court is required to terminate it right then, just upon motion of the parents.
If the guardianship is terminated voluntarily,
Right.
there's no requirement, at least that I see in here, Eric, that another guardian is lined up to take place.
Yeah, I think that's
when it's
correct.
terminated.
Yep.
So then it kind of goes back to my original question of what would happen to the child in this instance.
Yes, I think your witnesses might have a more, so that's sort of a practical, like, how does this operate in real life?
Sure.
You know, I think one would hope in the best possible world that they would file this motion to terminate only when there was a plan, some sort of plan in place as to what was going to happen.
You would hope.
You would hope,
Yeah,
right.
Thank you.
Yep. So it's a new language, top of page 19. This is again this motion to terminate that the parents have filed. Again, think about you see the language here says that in the case of a standby guardianship, the court may, for good cause shown, accept filings that don't meet the usual formatting and signing requirements for the rules of probate procedure. That's in there because if you think about it, where the custodial parents might be at that time, they might be out of the country by then. They might be back in their country of origin. And so the idea here is that it's not a requirement that the court waive the ordinary formatting and signing requirements, but it allows the court to waive those. Let's say the parent were not outside the country and say they were still right there and could comply with those, well, then the court could find, well, not good cause shown in that situation. But if they weren't available and their communication with the court was limited for some reason, for example, where they were, the court can waive those requirements. Also, the language on 11 to 13, similar kind of reason, rationale. I mean, the custodial parent can be permitted to appear at and participate in those continuation hearings remotely, because again, they might not be able to be physically present. And last thing, just so committee's aware, page 20, line 7-8, effective dates. So the section that this committee passed, H98, the confirmatory adoption piece, that takes effect on July 1st. That's line 7. Whereas the standby guardianship provisions take effect on passage. That's line 8. So different effective dates for the two different pieces.
Ian.
I just wanted to ask a couple of questions, which I think are for you now that you've gone through it.
Sure.
So now that we're potentially defining another type of guardianship, looking back through the definitions, it doesn't seem like there's anywhere where it explicitly defines consensual guardianship. Like it says child in need of a guardianship means, lays out all these things, talks about what a non-consensual guardianship is. And so I'm wondering if now that we have a consensual standby guardianship, if we need to sort of like clarify what actually a consensual guardianship is, or if it's just sort of like inferred.
Yeah, to me, it's sort of defined by the consensual guardianship statute, you know, and the requirements that I think that's 2626.
2626.
And now in the standby guardianship situation, 2626A. That doesn't mean you couldn't. I'm not saying you couldn't, but it seems like the requirements are laid out there.
Yeah, I just think if I look at 2626 and it says if the petition requests a consensual guardianship, and then I go back to the definition and I look and there's nothing that actually says what a consensual guardianship is. Although I guess you could just sort of say, okay, it's a guardianship that isn't non-consensual, but now we have another one that's standby.
Right.
So yeah, I don't know. I guess I can talk with the witnesses about it.
Yeah.
I think my other question was there any discussion in Senate Judiciary about standby guardianships applying to other consensual guardianship?
Mhm.
Like,
I mean, I understand. Not there was.
because I think one that I'm thinking about would just be someone who is struggling with addiction and is going into treatment, and maybe a similar structure. So I'm just wondering if so it sounds like that was not something discussed.
Correct.
Okay.
Yes, exactly. That didn't come up.
Okay.
Good point.
And then one other question I had was page 14, the court needs to be a showing by clear and convincing evidence that the child's custodial parent knowingly and voluntarily consented to the standby guardianship. Was there discussion in Senate Judiciary about how a court is going to accomplish that just on a written consent if the custodial parent isn't present because they've been detained?
Where are you at? 14?
I'm at two places. I'm on page 14, line 15, and I'm on page wherever the emergency thing is.
Yeah, that's page 12.
Thank you.
Yep.
Page 12, line, in case of a standby.
Well, that doesn't require, that's the,
Page 10, line 4. Right?
yeah, that's the reference to the.
I think basically saying that they can file it and the custodial parent doesn't need to be there. But, and so so my question, was there a discussion about whether the court, and I can ask Judge Zone this too, but I'm just curious if there was already a discussion about it.
No, but it's a very good question. In other words, what sort of evidence is the court going to look at other than obviously, because there's a requirement that there be this consent form.
Yeah.
But other than that, what else might the court rely on to make that finding by clear and convincing evidence? So good question.
And then last one for me is just page 19, except filings that do not meet the format and signing requirements for the motion under Vermont Rules of Probate Procedures 1011, page 19, lines 2 through 4.
Right.
In Senate Judiciary, was there a discussion about what the kind of rationale was for that language?
Yes. The rationale is that the custodial parent may be in a situation, for example, they've been removed from the country and they're not able to make a filing that is strictly in conformance with the formatting and signing. So in that situation, the court could, not required to, but could for good cause find, okay, I understand the circumstances. We're not going to require those in this case.
Okay, that makes sense. Thank you.
You bet.
Any other questions? Oh, I have a question.
In your opinion, I mean, you crafted this, without any of this language, and we ended up having some youngins abandoned or something with their parents, and there needed to be a way to take care of them, what would happen?
I think it's unclear because I'd say what would happen would be strong possibility they would end up in DCF custody. because
And DCF usually attempts to do what with children?
I think they would be in a situation where their actions are going to be defined by where the parents are. You know, are the DCF going to have to take custody for a period of time? How long is that period of time going to be? Depends on the nature of the detention and what happens with that. So yeah, I think their procedures of trying to provide for the child, attempt reunification are all going to be as they would be under current law, but also affected by the parent situation.
Could what we're writing here run afoul with anything that the federal government have going on with this if they know there's kids involved?
I'm not aware of any in this particular setup. In other words, because this isn't questioning or in any way affecting the underlying immigration action. Doesn't
Right.
affect that at all. So I'm not aware of any conflict. That doesn't mean, there isn't such a thing out there somewhere, but I'm not aware. Yeah.
Zach.
I think just following up on Representative Oliver's point, Eric. What's, oh,
Yeah, go
Sorry,
ahead.
Martin, I
No,
thought-
go
I thought
ahead.
you were
Go ahead. Yeah,
interjecting.
no, I just realized that coach has the
Do you think that there could be the perception, though, that this legislation is providing some kind of conduit to interfere with potential legal ICE activity?
That's kind of beyond my comment.
But a common theme, you know, like you look at 511 and S148, and there's tons of legislation that is under consideration currently where, you know, the governor's team has really real concerns that this would impact the state extremely detrimentally from a federal funding impact and collaborative law
Other
enforcement.
bills you're talking about, you mean? I missed that first part of what you said. I'm sorry.
The S148.
Yeah, right, other stuff. Yeah, other websites.
Yeah, but I mean, that's like a common theme, but to what Representative Oliver's bringing up is, like, could this be viewed, could there be the perception that this is running interference between federal law enforcement? And also delving into a jurisdiction that we do not have authority on, right? If this is like, my thinking, right, is that if the federal government is coming in and they are trying to, if the child is being deported, that's under federal oversight. It's not, like, this law would be null and void when it comes to, like, if it's criminal, right? Like, it would be null and void. It wouldn't matter if we pass this or not, if the federal government is coming in.
Well, it depends on what the status of that child is.
Right.
You know, like if it's a situation where the parents are detained, but the child isn't, then I don't think the proceeding would necessarily be null and void. But if something happens to the child, or the child's deported too, then yeah, this wouldn't apply to her.
Well, I'm thinking illegal entry, right? Because that's the criminal component of that, what we're looking at here.
Yeah,
Where the child, I mean, to no fault of their own, is in the country illegally.
right. I think that if the child is not detained, which the feds certainly have the option to do if there's some sort of illegal presence here, if the child's not detained, then this could be available in that situation.
But you don't have concerns about the constitutionality of it.
No,
Okay.
I don't. Perception wise, that's sort of for you guys to talk about, but
That's politics.
yes, exactly.
Yeah.
But I do think, at least from a legal perspective, this one is distinct from some of those other bills you're looking at in
I
the
agree.
sense that,
I agree.
that
So let me just follow up, just to looking at that slightly differently. There's nothing in this bill that keeps immigration authorities from detaining a child.
the fact
If they
reported,
don't, this applies.
right, that's good.
Tom?
If there wasn't any of this in this bill, we would have a way to deal with it.
Well, that's an interesting question, because I think that goes to what I was saying at the very beginning. It's because, yeah, that's rather ambiguous. And I think that's the idea. You look at, I look at, well, let's say, for example, leave DCF out of the equation for a second, because we talked about that. That's one thing, could end up at DCF custody. But is there a way to craft a guardianship to have an adult take care of that child? That's, I think, ambiguous, because that you'd have to rely on, I think, lines 12 and 13 of page 6. And there's a question there as to whether or not that's been something that works with the courts or not. I think that's kind of the rationale for, again, policy call is up to you guys. But if you think it's a good policy, as the nonpartisan drafter, I always say that if you guys think something is a good policy, be clear,
Mhm.
whatever it may be.
Any other questions for Eric? So we'll take a very brief stretch break.
Martin?
Before we go, Coach, go ahead. I missed your hand. Go ahead, Coach, first before we.
This will probably be covered by the witnesses, but back to the question of, let's say there's no political or criminal components to any of this, and we're dealing with a child, in need of services, then DCF will provide its regular, let's say, litany of services, of which would include investigating the potential guardianship, and they do a pretty extensive process, looking at kinship placements as well as emergency placements. But they'll cover that, for us procedurally. But having been involved in those investigations, where we've looked into, who is the closest person, and then investigate their backgrounds, and it's pretty extensive. So I just thought I'd throw that out as a general comment. Thank you.
All righty, so let's be back